is saying must be right. He says is right, but he just says, well, it's a very difficult...
I know that's what he says, but what I'm saying is the statute does seem to me to work very well without him having to make any...
No, I agree. I agree. The statute, there's no problem at all with the position as it is today. None at all. The question is there any difference with a payment or repair done on the 27th of June to the 28th of June?
That's what it's all about.
That's the issue.
Yeah.
And there's no... I don't say there's any difficulty with either. Let's be clear about that. And I don't say you have to adapt the statute for either.
No.
So...
If I may say so, I'm not sure that you've answered the starting point of my Lord's question about the purpose that you say. We're going to come to that.
No, I will answer.
I took your beam because I then took you up on something as well.
I welcome questions, absolutely, but I got distracted.
No, that's why I wanted to bring it back.
Thank you very much, my Lord. So if I can come back to that, what I was saying about the purpose. If once your Lordship, if we take the point that my Lord Legate was making, which I say is right, that Parliament obviously intends that a person who has to meet a liability, who they're saying now is liable, we take now, should be entitled to pass on in contribution that liability, or in a freestanding claim for damages if they have a contractual right or a tortious right to sue somebody, as we say we do here. So that's where Parliament has started. We say that's part of the parliamentary intention. In other words, Parliament's intention is both to ensure that homeowners and leaseholders are relieved of the burden of paying for these repairs. Take the cladding example. And we all know the problems that people face who live in a block of flats with cladding. The idea is that they and the taxpayer are relieved of the burden. So that's all common ground. But we also say, when Parliament does that, what it intends is that the person who then is now being made compellable in respect of their Section 1 DPA duty, because their limitation defence is being removed. That person should have a right to pursue others against whom they have a claim. So that's what we say is a fundamental starting point.
Sorry, you should have a right to pursue others. I mean, do you derive that from anywhere other than Section 1353?
We derive that from the statute itself, and from the acknowledgement that that this plainly does apply to retrospective to contribution claims going forward and damages claims going forward. What we say is it doesn't make any sense for Parliament to have intended that developers who had acted responsibly and had gone in to do the repairs shouldn't, now that Parliament has stepped in and says that you always were liable, that they shouldn't be able to pass that on.
I mean, I can see that, but I mean, we haven't been shown any materials to suggest that that was one of the purposes of the Act.
Well, you have the submissions of the Secretary of State.
Yes, but they don't refer to any relevant material.
But ultimately, I mean, one is, if one likes, one's trying to divine the purpose.
Well, that's why I asked whether there's anything other than in Section 1353. I mean, were that, it doesn't seem to me, but that there is any other material you can rely on, apart from saying, well, that would be a good policy.
There's no material on either side which addresses this point.
Yes.
So Parliament, I mean, the explanatory notes, my learned friend says they support his case. They don't. They're just, if you look at them, they're just giving a plain vanilla example of where you go and get a contribution. Hasn't addressed what about the works that people have been doing post-Grenfell, for instance. It doesn't address that. So your lordships are having to decide, in discerning what the policy is, whether the policy is that once you, that this only is, as it were, prospective in respect of, I mean, here repairs a very good example, that repairs that you carry out in respect of your DPA liability, but when you carried them out, the tenants, you were entitled to say to the owners, I'm doing it, but I'm actually, you're out of time, whether you're entitled to say, well, actually, they were in time.
Well, the question is the policy just to benefit homeowners going forward by giving them claims and encouraging developers to, or making developers liable to do work, or is it to benefit developers for work that they've previously done, which, let's assume, for the sake of argument, that they couldn't otherwise have recovered any contribution to?
Well, it's, when one says, the reason you can't, as it were, hive off developers, and perhaps in the way that your question suggests, in that at least I would respectfully suggest, the starting point is that Parliament, if we just take contribution, is taken to be aware of the Contribution Act, so that in changing the limitation period retrospectively, it is intending that you can pass on claims which you, taking your Lordship's example, which you now pay, post repairs which you do post the 28th of June, with 2022, you can pass on liability under the Contribution Act.
Well, that just follows automatically from allowing homeowners to bring claims against two parties. Well, if they're both liable, then they can claim contribution from one another.
Well, that's true, but it's part of what Parliament is doing, is allowing you to do that. In other words, it is saying, for all purposes, the limitation period has been extended. It doesn't matter between whom the argument is taking place. And the only debate we're having is whether it matters that what you were doing, the repairs you did, were pre the 28th of June. Now, I'm in danger of repeating myself. There's only a limit to what one can say on this. Ultimately, we say that the purpose of the statute is not as narrow as simply saying it is to benefit homeowners. It is, yes, to benefit the homeowners and relieve the taxpayer of the burden, but at the same time allow those who are doing the repairs to be afforded the opportunity to recover from those who are in fact responsible. And this is against a background, you have got to remember, it's against a background where the government, anyway, whether everyone calls that Parliament, but it was a matter of public record that the government was encouraging people to go in and do this. And so, if your Lordship, I mean, the Court of Appeal put it in when they were talking about a different bit of the argument, it's the same point, that what the consequence of saying that the statute is limited in the way your Lordship is positing is to reward the indolent developer, and the developer who was standing on their legal rights, and punishing the developer who behaved in a responsible way. Your Lordship might say, well, so be it, that's the consequence, but in my submission, that is an odd conclusion to come to on the statute in the context in which it was passed.
I think what I'm not quite clear is, I'm sure you're coming to it, what you say overall is the effect of 1353. I mean, you've used phrases like for all purposes, but do you mean that literally?
What I mean is, if the question arises in proceedings as to what, I mean, if one asks oneself if one asks oneself today, let's say that there are proceedings, and there is a question as to what is the limitation period under the DPA for a claim which are for buildings which were built prior to the commencement date. in my submission, if you're asking that question, there's only one answer. It's 30 years.
Well, can I put
Not
this
his book was the
idea to
limitation.
you? You say, for all purposes. Let's assume that a question has arisen as to whether what what BDW has done was reasonable. And the question as to whether it's reasonable is itself affected by whether there was a limitation period or not at that time. I assume you would not say that the question of reasonableness has to be judged taking account of a retrospective time limit.
Well,
You would have to judge reasonableness in relation to the time limit applicable at that point in time, wouldn't you?
Lord, surely it becomes circular. If I'm right that the retrospective period applies, then, I mean, if one thinks of the negligence case, if I'm right that the correct approach is that one says BDW is to be treated as not having a limitation defence, then the questions, ground one falls away.
No, I'm putting to you just this hypothetical.
Right. But
You wouldn't judge reasonableness there other than on what the historical position was, that there was that the limitation period had run out.
But, my Lord, the reason I'm hesitating, I'm just not really following the premise in this sense. If the statute is retrospective,
Yeah.
then where I'm struggling is to see why the question of whether you had a limitation defence arises, because the statute is saying there wasn't a limitation.
Well, Mr. Howard, an example would be if the proceedings were brought against the directors under the Directors' Disqualification
Yeah.
Act for failing to make proper provision
Yeah.
in 2018 against a liability which at that time was statute barred. But 4 years later, the limitation
Okay.
period is extended.
Let's-
So take that very
I'm going
example.
to take that.
Would the directors be disqualified?
Let's take that first.
Yeah.
Let's take it on what is common ground, both with the other side and with the court. So you have the limitation period expired in 2012. Let's say the company has been worried corporate